Be ready. Start. The rule of equality or equal protection does not require that a state must choose between attacking every aspect of a problem or not attacking the problem at all, and particularly with respect to social welfare program stop. So long as the line drawn by the state is rationally supportable, the courts will not interpose their judgment as to the appropriate stopping point. Stop. A statute is not invalid because it might have gone further than it did, since the legislature need not strike at all evils at the same time and may address itself to the phase of the problem which seemed most acute to the legislative mind. Stop. A classification based on experience was a reasonable classification and that it had a rational nexus to the object thereof, and to hold otherwise would be detrimental to the interest of the service itself. Stop. This opinion was taken by this court in the case of State of UP and others versus JP Chaurasia and others within bracket 1989 1 SCC 121. Stop. Classification on the basis of educational qualifications made with a view to achieve administrative efficiency cannot be said to rest on any fortuitous circumstances, and one has always to bear in mind the facts and circumstances of the case in order to judge the validity of a classification. Stop. In the case of State of Jammu and Kashmir versus Shri Trilokinath Khosa and others within bracket 1974 1 SCC 19, it was noted that intelligible differentia and rational nexus are the twin tests of reasonable classification. Stop. If the law deals equally with numbers oblique members of a well-defined class, it is not open to the charge of denial of equal protection. Stop. There may be cases where even a single individual may be in a class by himself on account of some special circumstances or reasons applicable to him and not applicable to others. Stop. Still, such law can be constitutional. Stop. Constitutional Law of India by H.M. Sirvai. Stop. In Maneka Gandhi versus Union of India and another 1978 1 SCC 248 and Charan Lal Sahu versus Union of India within bracket Supra, the court has taken the view that when the constitutionality of a law is challenged on the ground that infringes a fundamental right, what the court has to consider is the direct and inevitable effect of such law. Stop. A matter within the legislative competence of the legislature has to be left to the discretion and wisdom of the framers, so long as it does not infringe any constitutional provision or violate any fundamental right. Stop. The law has to be just, fair, and reasonable. Stop. Article 14 of the Constitution does not prohibit the prescription of reasonable rules for selection or of qualifications for appointment except where the classification is on the face of it unjust. Stop. We have noticed the challenge of the petitioner to the constitutionality of section 12 within bracket 5 and 6 and section 15 within bracket 5 and within bracket 6 of the Act of 2005. Stop. The challenge is made to these provisions, stating that the eligibility criteria given therein is vague, does not specify any qualification, and the stated experience has no nexus to the object of the Act. Stop. It is also contended that the classification contemplated under the Act is violative of Article 14 of the Constitution. Stop. The petitioner contends that the legislative power has been exercised in a manner which is not in consonance with the constitutional principles and guarantees and provides for no proper consultative process for appointment. Stop. It may be noted that the only distinction between the provisions of section 12 within bracket 5 and 12 within bracket 6 on the one hand and sections 15 within bracket 5 and 15 within bracket 6 on the other is that under section 12 it is the central government who has to make the appointments in consonance with the provisions of the act, while under section 15 it is the state government which has to discharge similar functions as per the specified parameters. Stop. Thus discussion on one provision would sufficiently cover the other as well. Stop. Over.